Hello and welcome to the Catholic Camel Law Office Legal Podcast, the NJ Laws 2. In this edition, we're doing our program from the New Jersey State Bar Association annual meeting in Atlantic City, and we're talking about recent major cases that affect the New Jersey criminal courts and municipal courts, and we're going to look at cases 9 through 16. And so now number 9, let's see, can police search a passenger compartment of a car incident to arrest after the suspended driver is handcuffed and locked in a police car? And according to the United States Supreme Court, the answer is no. Arizona versus Gant, 129 Supreme Court. The Supreme Court held the police cannot search a car passenger compartment if the occupant is already arrested. The Supreme Court held police may search the passenger compartment of a vehicle incident to a recent occupant's arrest only if there is reasonable reason to believe that an arrestee might access the vehicle at the time of the search or that the vehicle contained evidence of the offense. The Belton case was overruled, and that's Arizona versus Gant. Case 10. Can police is being in a car where they find drugs automatically constructive possession? No. State versus Reeds, 197 NJ 180. Now Reeds basically dealt with a situation where the trial court permitted a police expert to testify as to what was constructive possession in his opinion, and Supreme Court said, well, that should be what exactly is constructive possession really should be a decision by the jurors and not told to them by an expert. But they did give a definition of what constructive possession was, and they said such possession can be constructive, meaning that, quote, although a defendant lacks physical or manual control, the circumstances permit a reasonable inference that the defendant has knowledge of its presence, the drug, and intends and has the capacity to exercise physical control or dominion over it during a span of time. And that's State versus Reeds. Let's see. 11. This case deals with signs, street signs, road signs. Let's say there's no testimony by the police that a U-turn sign was properly posted and the road was not a highway. Is that a defense? And in State versus Smith, the answer is no. There's a rebuttable presumption that a sign was properly posted. And the fact that, although the statute says highway, they said that really is not a defense, and that, let's say, there doesn't have to be a complete U-turn for a violation to occur. And that was State versus Smith. Let's see. 12. Does an arrest that's based on a mistaken invalid arrest warrant suppress drugs and guns found? Well, that's interesting because the United States Supreme Court in Herring versus United States said yes. Herring's at 129 Supreme Court, 695. The Supreme Court found an arrest and search by police based on an invalid warrant does in Herring, just to be clear, it says it doesn't suppress the guns found, but, and here's the but, in State versus Handy, the New Jersey courts found that's a little different. They're not, New Jersey found, based upon the New Jersey Constitution, that because there was a mistake, that would suppress the guns and the drugs found, or anything that was illegal that was found. I think it was just like this drug. So, although a New Jersey court cannot overrule a Supreme Court case, based upon New Jersey Constitution, a court in New Jersey can give greater rights to the defendants, and that's the State versus Handy. 13. The DWI cases. In the Chun landmark DWI case, the Chun court wrote, inspections of the machine should be every 6 months, not 1 year. Let's say there was a DWI case still floating around prior to the decision in Chun, and the state failed to inspect it within 6 months. Is that a defense to throw out the alka test? In the State versus Pollock, the appellate division said no. The 6-month inspection period does not apply until after March 17, 2008, when Chun was decided. 15. DWIs and refusals. A DWI can be charged on private property. It could be someone on a tractor on their private farm. A refusal, though, is supposed to be quasi-public. What about a high-rise condo parking lot? Is that quasi-public where a refusal could be charged? And the answer was yes. In State versus Bertrand, the condo parking lot is quasi-public, so if someone refuses at stop, or the police find them there, that's grounds. Let's see. DWI in Chun again. Chun says the operator must observe a suspect for 20 minutes. What about, does it have to be the operator? Although the answer is no. Although the Chun decision says the operator shall, State versus Ugrovics said the state must prove the 20-minute observation of the driver prior to the breath test by clear and convincing evidence. But the arresting officer can also testify as part of the 20 minutes as well as the alcohol test operator. And that was State versus Ugrovics. 16. PTA guidelines don't require a guilty plea as a condition for PTI. Can a guilty plea to a traffic offense be required as a condition for PTI? And the answer to that is yes in State versus Maja. PTI can be conditioned on a plea to a traffic offense. 17. Let's see here. Can a Miranda violation be argued by a co-defendant where the is to keep out statements and then suppress what was found? In State versus Baum, the answer was no, that the failure to give Miranda might be used by the person who gave a confession, but it can't be argued by a co-defendant, and that was State versus Baum. For additional information on recent criminal and traffic cases, visit website njlaws.com. That's njlaws.com, or website benotguilty.com. That's benotguilty.com. For other information on criminal cases, contact the Law Office of Kenneth for Kamen, 732-572-0500 at 2053 Woodbridge Avenue in Edison, New Jersey. Thank you and good luck, and we'll continue for the rest of the cases in our next NJ Laws Legal Podcast.